Okay, all right, counsel, thank you. Our next case is 14-3633, Alberto Sanchez versus Reemployment Assistance Appeals Commission.
Good morning, Your Honors. May it please the Court. My name is Laura Pichardo Cruz. I'm with Community Legal Services of Mid-Florida for the appellant, Mr. Alberto DELEON Sanchez. This is an appeal of a final order by the Reemployment Assistance Appeals Commission, which affirmed the decision by an appeals referee below, which determined that Mr. DELEON Sanchez was ineligible for unemployment compensation because he was terminated for misconduct, as that term is defined by Florida statutes. Mr. DELEON Sanchez was, at the time of his termination, employed by Malibu Quality Greens as a fern packer for almost 24 years. There is no competent evidence on the record of any previous reprimands of this claimant, despite some very vague statements by the employer during her testimony at the hearing below. There is no development of the record with regard to previous reprimands. Not only was there that vague statement by the employer, this question was not asked of the claimant himself. During his own testimony, the appeals referee never asked him, had he been reprimanded, had he faced any sort of discipline at the workplace. This failure to develop the record results in really a lack of competent evidence with regards to any previous instances of misconduct on behalf of the claimant. So our first argument in this case is that there is not enough competent substantial evidence to uphold the idea or the finding that Mr. DELEON Sanchez committed misconduct.
Let me interrupt you. So you
Yes.
agree that Mr. Sanchez's duties as part of being a fern packer is to clean up the packing area? We all agree to that, correct?
Well, actually, Mr. DELEON Sanchez repeatedly said his duty was to clean his own work area, and that's actually in the findings of facts of the appeals referee. The appeals referee says his duty was to clean his own work area. There are repeated instances in the record where Mr. DELEON says, I cleaned my area. It was only after the employer threw additional dirt on my area that I said, I'm not going to do that. Now, and there's also an instance on the record during the employer's testimony in page 67 of the transcript where she says to the referee in answer to a question, he said to me, he meaning Mr. DELEON, I am doing that. So there is apparently even some admission there on the part of the employer that Mr. DELEON was performing his job duty.
Now, the referee found, though, that your client disobeyed in order to clear or to clean the packing house. Correct?
Yes.
Now, you're saying it's just an error in judgment, but cleaning up the work area, whether it's whatever you described, the zone of his area only or the packing house, that's not an unreasonable request of the employer, is it? His area?
Well, I think whether the request is reasonable would require more information. So there's repeated instances in the record where Mr. DELEON cites to potentially abusive practices by the employer. And this is uncontroverted testimony on the record. So for example, during his testimony he says, she would constantly come at me with different opinions, switching it up on me as far as my work duties went. She constantly gave me more work, never wanted to provide raises or increases in pay, but more work. He gives us a specific example about
There's other testimony that contradicted what your client was saying about his past refusals to clean up and things of that nature. You agree, don't you?
Actually, I'd say the only testimony on the record would be the employer's testimony saying he was spoken to about it for a while, and that's during her initial testimony. There's no follow-up questions by the referee with regards...
what is it, Sozer and Cruzette, the other employees?
Well, Mr. Kursev, who's the first employer witness, has no first-hand knowledge of the incident, and he says so. The second witness, which is Mr.
About your client complaining.
But he doesn't have first-hand knowledge of the incident in question, which was the date of the termination.
I'm just going to the prior history. You said there was none, but there was some, perhaps not by the employer itself, but by employees, co-employees.
Well, we could say there's scant evidence on the record. I would argue that it's not competent evidence on the record. And if we look at the question posed to Mr. Sosa, who's the second witness, The referee does not ask him about specific instances. The referee says, tell me about, and I'm quoting here, the latter part of the claimant's employment. Very vague questioning, and from that, no follow-up questions, no examples, no testimony elicited from any of these three witnesses with regards to specific instances of the claimant's alleged failure to perform his job duties. No questions about any of these witnesses with regards to the disciplinary policy in the workplace. If there was actual warnings, what kinds of warnings they were they verbal in nature, were they written? None of this stuff was asked. And then when they turn to when it comes time for the claimant himself to present his testimony, he is never asked, hey, you've heard the testimony of these three individuals, what do you have to say about it? He's never asked about that. So, we really don't have any information from the claimant himself, any opportunity for him to answer with that, in that regard. So I would say, coming back to my point, that a reversal in this case would be appropriate, and I think that given the evidence we have, given the scant evidence, given his long tenure with the company, the lack of competent evidence that I've just described, and the uncontroverted testimony on the record that he faced potentially abusive practices in the workplace, I think that we can classify this as an isolated incident of poor judgment, and I think the case could be properly reversed. Now, I think that a second way that the court could approach this is a remand. I think it would be within reason to remand this case for further proceedings. I do think, as I argued in the brief, that the appeals referee has a basic duty and obligation under the administrative code to develop the record. I mean, this is an area where both parties, both claimants and employers, appear at these hearings largely unrepresented. They're unsophisticated, they're pro se, and in order to make these hearings meaningful, in order to safeguard due process, that we have to hold referees accountable to their duties, as those duties are enumerated in, as I stated before, the Florida Administrative Code. The Department of Economic Opportunity realizes that these duties are central to these proceedings, and they train referees, and that's the manual that is cited in both our brief and the appellee's brief. Referees with just the basic rudimentary training are told they must develop the record. That's their duty, to develop the record, to examine, cross-examine, to get to the bottom of things. And it's precisely because most of these parties are pro se, and they rely on the referee to develop that record. I think there are a variety of instances on the record where we see the referee failing in his duty to ask the most basic questions. I think if we go back to the reprimands, that's a major flaw of the record, that he does not follow up with any questions. In the case of either the employer or the two witnesses that appear, no follow-up whatsoever, no details elicited whatsoever. I think there's also instances in the testimony of Mr. DELEON where he is trying to convey to the referee, this is how the employer was, As I stated before earlier in my argument, Mr. DELEON tries to convey, she would come at me with different opinions. She would give me more work. She had a strong character. He gives a specific example of stacking up cardboard boxes. She comes and knocks them down. Each and every one of those instances is met, literally, that the referee says, okay, that's it, no follow-up. He does not go back to ask Ms. Moore, the employer's chief witness in this case, tell me about these allegations by the claimant. All he says is, okay, he's dismissive, and goes on and says, let's just talk about the incident of April 18th, which is the day of the separation. So these, I would argue, are very, very basic failures on the part of the referee, and these are things we really need to know, and we need to know them because, one, we want to know, are there previous reprimands? Is this a pattern of behavior, or is it isolated? And I think, two, in order to determine whether the request by the employer is reasonable, we need to know in what context was it made.
I hear what you're saying, and I understand what you're saying, but doesn't the law also indicate that a one-time event can be the basis for denial of reemployment benefits, especially when the act in question is something that's an essential requirement of the job itself?
Yes, there is case law that says a one-time event can be, is enough, but there's plenty of case law to suggest that a claimant with the amount of years invested in this employer, a claimant where there is no competent evidence of any previous reprimands, a claimant who...
Just discounting what the two other employees testified to, right?
Well, no, I mean, I think my argument is, obviously I can't negate that they said it, it's there in the transcript. My argument is that it's not competent evidence. It does not support the conclusion that there were actual reprimands, okay? So if we say, what is a reprimand? Well, we have to know what's the policy, what's the disciplinary policy, what's cause for a reprimand in this workplace, who issues the reprimands, who supervises you. You know, all these things had to have, I mean, a referee with the most rudimentary training would have asked these questions, and these questions simply weren't asked. So what we're left with on the record is very slim information, and I would argue that that's not competent evidence of previous reprimands. I think that we have to look at the context of this claimant's job. I think that it is important that he was there for 24 years, and we can glean from the transcript that he had a long relationship with this particular individual, with Ms. Moore, who's the owner and the president of the company. So, you know, I think that we have to look at that and say, do we feel comfortable telling an individual who spends 24 years in a company where with a record with such scant evidence of previous reprimands, with a record which has as many flaws as this one does, quite frankly, and say to that claimant, you know what, after these 24 years, with what we have, this slim record that we have here, you still get nothing. Despite your application for benefits, despite your 24 years in, we're not going to award you a penny. And that's what the state of Florida has affirmed, and that's what they'd like this court to affirm, and I think that really fundamentally, quite frankly, is unfair, and I think it goes against the statute. I think there's case law that would support a finding that this is an isolated incident of poor judgment, and it should be reversed. I'm going to go ahead and save my time and...
Okay, you have 8:20.
Good morning, Your Honors. Frank Brown, Chairman of the Commission, and it's unusual for me to be here, but unfortunately a number of conflicts with my appellate attorneys have left me holding the fort today. So perhaps...
Can I interrupt you before you start? I just want to clarify some things. You agree that Mr. Sanchez is supposed to clean up as part of his duties, right?
Yes, there were no less than four circumstances or instances in the testimony where...
But that's it. Now, he's a fern packer, right? He's not a maintenance man.
Correct.
All right, so in deference to Judge Cohen, it sounded like the appellants were arguing we have a cool hand Luke situation here today, a failure to communicate, a digging of a hole and then filling it up. And because, as the appellant indicated, this is a 24-year employee who is being denied reemployment benefits for failing to clean up a mess left by a wasp nest that the employer knocked down. He didn't knock it down. It wasn't part of his fern packing duties. It was something the employer did. So what do you say as far as what the appellant was arguing?
Well, and you needed to be here Tuesday when Judge Cohen was talking about the Roadhouse movie.
I know the reference well, Your Honor. The first accredited evidence of the employer reflects that cleaning was part of his job duties. There was no less than 4 occasions.
Not a maintenance man.
That's correct.
He's a fern packer.
But it was part of his duties to clean up the packing house. So that's accredited evidence that the referee made the finding on. With respect to the dirt, I think the record's somewhat equivocal. The claimant initially said that she threw it down. Later on, he made the statement that she brushed it down. It was from nest. The claimant's the employer's testimony, which again was the side that gained the benefit of the credibility determination, was that it fell down. But clearly, there was dirt that had gotten down in front of the cooler. The cooler, by the way, is the area where the fern packer puts the ferns. It's part of the area he would walk through. So the argument as to what his work area was versus the entire house is really kind of a non-issue in this case, because his testimony at the hearing, he never said, I didn't clean the dirt because it wasn't in my work area. The first reference he ever made to that was in his appeal to the commission, and we don't accept a new contention at that point, absent.
This is a 24-year employee. There was no evidence by the employer herself of prior misconduct. Do you agree with that?
The only evidence was that he had expressed some attitude issues, but nothing that would rise to the level of a specific formal reprimand in the record, correct?
Keep going.
Well, as you pointed out in your in your examination of the appellant, the law is clear that there are acts for which a single-time incident, even for a long-time employee, constitutes misconduct. And perhaps the most fundamental one is failure to obey a valid work order. The evidence in this case, taken in the light most favorable of the employer, is that it was a reasonable request for him to sweep that area up, and that he refused to do so. He made it clear that because he'd already swept the area, then the additional dirt got there either because the employer brushed it down or it fell down, he decided not to do that. The corroborating witnesses testified that that's exactly why he said that he left. He told Mr. Sosar that was why he was leaving. So if this is a valid work order, and we believe the referee is correct in concluding on these facts that it is, his refusal to do it constitutes misconduct. That's the general rule. Now, as this court has noted in some exceptions, there are cases of exceptions to that. But to refuse to obey a valid work order, there has to be some circumstances that would allow a person to reasonably refuse it. This court is, one of the most recent cases, and perhaps the most pertinent, is the Laneri case written by this court, in which the court noted that the claimant was told to make a flight that he reasonably believed would possibly violate FAA regulations, would possibly put himself and his passengers at risk. The other cases the appellant cites for the idea that refusing a work order isn't always misconduct are perfectly reasonable cases in the context of those cases. They involve scenarios where one would reasonably assume that a claimant might not do the job that he was asked to do. If I could just provide some examples. The Crosby case, the claimant was asked, after making a good faith report of child abuse, was then told by her supervisor to write a letter of apology to the parent who she turned in because she believed there was child abuse. And she not only believed it would result in additional harassment of her by the parent, but it could potentially subject her to criminal procedures, criminal prosecution for making a false claim of child abuse in that case. The cases where a single instance of refusal to obey a work order has been held not misconduct are cases that have pretty significant facts that suggest that the order itself was not reasonable under those circumstances. Another case like Baca was a case involving an employer told the claimant to talk about his workers' compensation case when they knew that he was being represented in a proceeding about it by counsel, something, again, that would not be a reasonable thing for the employer to ask. This case does not suggest any type of unreasonable behavior unless you accept the claimant's testimony, which the referee didn't, that the employer had basically just thrown something down there to annoy him and to antagonize him. That is not what the record taken in the light favorable to the employer suggests in this case. The claimant just simply did not want to do it for reasons that are inexplicable for someone who has been working there so long. And as to the credit a person gets for working there for so long, there's no question that the law considers that issue. But what it helps the court and the referee to do is to decide if someone has been working for a long time, they've developed a track record of compliance and performance. So you may give them, in certain circumstances, the benefit of the doubt, but the record here is clear that for whatever reason, he simply decided he did not want to do what he was instructed to do that day. I primarily came here to talk about the procedural issues, unless they were not addressed directly on the beginning of the argument. Unless the court had any questions on those, I will just rely on our briefing.
Thank you, counsel. That's fine. counsel. You have 8 minutes, 20 seconds rebuttal if you'd like.
Well, I only want to make one point with regard to the case law cited by the appellee, by Chairman Brown. If we take a look at cases like Lanier, the other cases that are cited in the briefs, and we ask ourselves, was the request reasonable and was the refusal reasonable? I think we have to tie back to the failure of the referee to develop the record. I think that there are numerous instances, as I stated before, of this claimant trying to convey the abusive practices of his employer and being repeatedly either dismissed or, in the very last instance, shut down by the referee who says, come on, sir, basically saying, you're under oath. I want you to, think about your answer. You've been placed under oath. So the referee really, on a repeated basis, shuts down any attempt by the claimant to convey to the court the abusive practices of the employer, which really would shed a light on to how reasonable a request it would be, and how reasonable perhaps the refusal would be, which is also, according to the case law cited, just as important a factor in determining these cases. Now, I understand that in the Lanier case, we're talking about an airline pilot. This court makes reference to the pilot's need to for the safety of his passengers, and there was some weather conditions. But the court also notes the amount of time that the pilot spent in his place of employment. He was there for 4 years without any reprimands. Obviously, not all claimants can be airline pilots with people's lives in their hands. Some claimants are fern packers, they're laborers, and I think that we have to look at the case law with respect to their workplace, in light of their workplace, and I think that my client repeatedly tried to convey those facts and those elements, and he was repeatedly shut down. And I think that we can look at this case as I stated before, isolated incident of poor judgment, and reverse it and award benefits.
Thank you, counsel.
Thank you.